Charles Chauvel.
Thank you, Mr Speaker. Mr Speaker, on the 16th of June 2005, Supreme Court delivered reasons for judgment in the Bryson and 3'6" appeal. That court, on that occasion, comprised 5 of New Zealand's leading jurists, including the Chief Justice and a judge who is now a member of the International Court of Justice. The court heard submissions from the parties, as well as from Business New Zealand and the Council of Trade Unions as interveners. It was one of the last appeals that I had a role in arguing before I came to this House, and I can assure every member here that it was fully argued, as the 20-page judgment from Justice Blanchard indicates. And there's proof of the soundness of the decision of the court, sir, in the fact that Bryson is the last appeal to have been heard on the question of how to resolve whether a workplace relationship is one of employer or contractor for 5.5 years. The law reports don't contain another one. The appeal settled the proposition that the law that has characterised an employment relationship for at least the past century in this country was unchanged by the Employment Relations Act. And the law is this: that all the attributes of the relationship have to be considered, not just the label attached to it by one or other of the parties, whether at the start of the relationship or at some point while it's on foot. And this law has served us well, Mr Speaker. When I was in legal practice, my international employer clients, especially those from the US or Europe or Australia, were generally struck by the flexibility that New Zealand law gave them in being able to set up business arrangements here. All that is needed is to take care to properly and honestly document the relationship at the outset. The background that I've just described makes this amendment all the more outrageous, even before we consider the circumstances of its introduction. And the lack of basic understanding of the law that we've heard exhibited by government speakers, including the Minister, just makes it worse. This amendment deprives workers in the film industry of the right to collectively bargain by specifying that they should always be treated as contractors. But it goes on then to undermine that primary provision by specifying that if a worker is a party to an employment agreement, then he or she shall instead be an employee. And thanks to a further amendment tabled by the Minister last night, any such employment agreement must be in writing. Well, sir, the first point is there's no need for this amendment. As I said earlier, the Supreme Court settled the law in this area 5.5 years ago. There's been no litigation since, because it's clear that as long as the parties describe the relationship between them honestly and accurately at the outset, no problem arises. But more importantly, this amendment will actually create uncertainty. The default position is that film workers will be contractors. But if, as they're heavily incentivised to do in the event of a dispute, they wish to argue for the greater protections that employment status give them, workers whose status is arguable will invoke that proviso. They will say, we are employees. And if they do, what will they have to prove to the Employment Relations Authority? First, that they are parties to an employment agreement. In order to do that, they will have to show that the reality of the relationship is one of employment, not of independence. In other words, to take the authority through all of the tests that were traversed in the Bryson case. The Supreme Court settled that law 5.5 years ago, and here we have Parliament, under the misguidance of the Minister, reopening the issue and making many more Bryson-type cases more, not less likely. And in many cases, thanks to industry practice, those workers will win their argument that they are in fact employees. But there's something worse than this, sir. The Minister thinks that by specifying that any employment agreement has to be in writing, and by doing that she can fix the problem. Well, she hasn't read the Bryson decision, because in that case the court was very clear that very few employment relationships are comprehensively documented in one place. So what is an employment agreement in writing in terms of the Minister's supplementary order paper? Is it a standard term sheet? is a letter of appointment? What about a written agreement that's labelled to be an employment agreement, but which clearly documents an independent contracting relationship? The Minister's amendment to her amendment actually raises many more questions than it solves. And again, it will create much more, not much less, litigation potential. So Section 6 of the Employment Relations Act was a very carefully drawn provision. What arrogance this government showed yesterday in its attempt to amend that section. It introduced a clumsily worded amendment, which it has already had to amend once, thinking that without a select committee process or the nicety of more than a 5-minute second reading speech from the Minister of Labour, it could adequately exempt the film industry from the operation of the Act. That attempt will not work, and it is simply a recipe for further uncertainty and more litigation, the exact opposite of what John Key appears to have promised Warner Brothers and Peter Jackson and everybody else. So, Mr. Speaker, we've got a bad law, achieving the reverse of what's intended, being passed under a defective process by a minister who is not on top of her brief. But as has been pointed out time and time again in this debate, although these things are bad enough, they're not the worst aspects of the work that the government is forcing on Parliament today. Sir, because the first thing about this amendment, the worst thing about it, is that it clearly comes at the behest of a government that only 2 years into its term has just run out of ideas. Mining national parks didn't work. Appropriating Canterbury's water and turning the emissions trading scheme into a big subsidy for polluters may have led to lots more dairying, but it hasn't delivered prosperity. So what does the government have left to do? Give in to any multinational that asks for a labour standard to be diluted in return for some investment? What's going to be offered? And it can't even do that right. That's right. And what's going to be offered up next? Environment standards, human rights norms, health and safety and employment law? What's going to be next on the bidding block, we ask ourselves?
The Roman Balancing Clause.
Sarah, I just want to
reduce the age of consent.
I just want to pause for a moment to reflect on the path that this government has begun to tread. Phil Goff, when he was Trade Minister, signed an agreement with China that's being implemented over 12 years. It records that China and New Zealand regard it as inappropriate, Mr. Speaker, to encourage trade or investment by weakening or failing to enforce labour laws. We've agreed with the Chinese not to weaken our labour laws. Well, what a fine example we've set today for the implementation of the China-New Zealand Free Trade Agreement. And what a great negotiating signal we're sending to the United States and others in the context of seeking agreements with them over our commitment not to arbitrage the terms and conditions of our workforce. Wow. Sir, people thought they were choosing a brighter future under this government. They thought that members opposite were ambitious for New Zealand. Once the euphoria of retaining the Hobbit in New Zealand wears off, and once all the union-bashing bloodlust dies away, people are going to be pretty disappointed with what remains. A government, sir, that has reduced New Zealand, in the words of the Financial Times today, to client status of an American film studio. And, sir, those people will realise that it's only under a Labour-led government that Kiwis can have any hope of owning their own future.
I call Dr. Jackie Blue.
Speaker, I'm pleased to be speaking to